So this is an arbitration proceeding. That is a form of alternative dispute resolution. It's an alternative from being in court. So both sides have agreed to arbitration. The obvious advantages to arbitration are that it's arguably faster, it's cheaper, it's much cheaper than a trial. You're saving yourself $15,000, $20,000. And it's a little bit more predictable, which is good for you and I because we're probably going to get some money. Mm-hmm. It's good for the insurance company because they're sort of comfortable that an arbitrator is not going to give you a runaway verdict. Mm-hmm. And none of us know which of the things in between might happen, right? Mm-hmm. So if you went to trial with a jury, you could lose. This is like a threshold case, right? I don't feel that way, but the law would say it's a threshold case. And so you risk like getting zero. Mm-hmm. And the insurance company risks that the jury really likes you and gives you $100,000, which is like more than what the case is worth. Mm-hmm. Arbitration in this scenario is a controlled environment and both parties agree to do it. Sometimes arbitration is forced upon the parties. That is not usually good, at least from my perspective representing human beings, because generally they favor corporate interests. But here I think it was a good idea because again, you have like what we call threshold case. It's right on the line of, is this the type of case that really should just be covered by no fault, or does your injury satisfy the threshold? So an arbitration proceeding means that you don't get a jury, you have an arbitrator. Sometimes they're designated by like the American Arbitration Association. In this scenario, the two lawyers, myself and the attorney for the insurance company, agreed on an arbitrator. So in this case, your arbitrator is a well-experienced lawyer who has been handling these types of cases for a very long time. And so we trust that he knows the issues and will, do the proverbial sort of split the baby. Now, he doesn't know our agreement that, we've capped the damages, but, he'll probably give you a number that the case might otherwise settle for if the insurance company wasn't being so recalcitrant, all right? So we've made submissions. Both sides put in papers in advance. So like I wrote up a summary of your case, highlighted the strengths and the weaknesses, provided pertinent medical records, and so too did the other side, okay? So the arbitrator has documentation, evidence, if you will, that will support both the respective parties and their positions. Some arbitrators don't read it before so that they go in with an unbiased perspective. Some read it before so that they go in and can anticipate the issues. I don't know what this arbitrator style is, but that's just, so he may act ignorant of the facts and he might actually be ignorant because he wants to hear it for the first time today. And then generally what will happen is at the conclusion of the proceeding, the arbitrator will do a write-up, write a decision basically, and then make an award or not, but there's usually a write-up. And so it's usually after the fact that they would rely on some of the documentary evidence and things like that. So they have all the evidence in advance, and today you'll testify. Mm-hmm. Now you can call other witnesses. Sometimes I'll call the experts, right? Big cases, I'll call the expert, the neurologist or the orthopedic doctor or the spine surgeon. Your case, we're trying to save money, right? I want you to net more, so I'm not calling the experts, but we put the experts' report in evidence. So you had a doctor who wrote up a narrative. They have two doctors. They had the doctor who examined you, and then they had a radiologist look over the films. So we have expert opinions, but they're in writing, done in advance, and we submit them, okay? So that's kind of an arbitration in a nutshell for your case, okay?